Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. Well, for those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website, and we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Understanding Medical Negligence Claims. My name is Amira, and I am a pupil in Chambers in Malkai & Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Malkai & Associates is a mid-sized law firm that was founded in 1985 by Datuk Wong. Our able team today comprises 22 lawyers and a support team of 19. Datuk Mah is today a consultant in the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small, medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration, an employment law and industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas which are supported by talents from both our corporate and dispute resolution team. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, and some of which had been broadcasted live. But due to the COVID-19 movement control order, we have moved online in order to continue with our objective of sharing legal knowledge, raising awareness, and encouraging networking between clients, potential clients, and in-house counsel. This is our 15th talk in our online talk series in 2021. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. The details will be given at the end of this talk. Today, we have two speakers. Jasmine will be speaking first, which is on the overview on the law of medical negligence and obtaining and disclosing medical and hospital records. And Chee will be speaking later on medical reports and expert witnesses. We will then conclude with a Q&A session. Now, allow me to introduce both of our speakers for today. Firstly, Ms. Jasmine Wong. She was admitted to the Malaysian Bar in 2017 and is currently an associate in our Dispute Resolution, Employment Law and Industrial Relation and Individual and Family Department. Next, we have our second speaker, Mr. Wong. He was admitted to the Malaysian Bar in June 2020 and is an associate in our Dispute Resolution and Individual and Families Department. Now, if along this presentation you have any questions that you would like to ask, please feel free to post it in the Q&A chat box, and we will be answering it at the end of this talk. Now, to be fair to the speakers, we would appreciate if you could confine your questions to the topic that is being discussed today. Now, without being further ado, I would like to pass the floor to our first speaker, Ms. Jasmine Wong, who will be speaking on the overview on the law of medical negligence and obtaining, disclosing medical and hospital records. Over to you, Jasmine.
Hello, everyone. I'm Jasmine, and I'll be your first speaker for today. Thank you so much for giving us your time this afternoon on a Wednesday. Let me just pull up my screen. Mira, can you see my screen right now?
Yes, I can.
All right. Well, everyone, the title today is Understanding Medical Negligence Claims. So first of all, what is negligence? Professor Fleming, some of you who read law would know, Professor Fleming has actually written a book on tort. He said that negligence is the conduct falling below the standard demanded for the protection of others against unreasonable risk or harm. Lawyers and law students, for example, would know the case of Donahue against Stevenson. Now, this case concerned a consumer who found a decomposed snail in the ginger beer bottle. The court in this case made a decision to say that the manufacturer of the ginger beer drink owed a duty of care to his consumers to make sure that no snails enter into the bottles, and also to inspect that the ginger beer bottles were free from contamination before the pouring and sealing, and after that marketing to the general consumers. It is from this case that the principle of duty of care arose from. Based on this case, it says that we must take reasonable care to avoid any acts which we can reasonably foresee that would injure our neighbor. Neighbor being a person who would be so closely related that may be directly affected by our acts. So in the terms of medical negligence, it talks about the provision of healthcare in particular. And we are looking in the context of when a doctor, a medical practitioner has fallen below the acceptable standard of care and causes injury to the patient. Now, the discussion on medical negligence today would focus mainly on doctors, but these same principles are applicable to other healthcare professionals as well, such as nurses and dentists. Elements for negligence. Before we would even consider a claim for medical negligence in court, we will need to satisfy a few elements. First of all, there must be a duty of care. And this arises between a doctor and a patient relationship. Because if a doctor does not owe a patient any duty, then there is no duty for the doctor to even treat you, advise you, or give you general care or medical treatment. Once there is an established duty of care between the doctor and patient, the next element to be satisfied is that the patient must prove the doctor has actually breached that duty of care. The patient must in fact show that the doctor has failed to follow a reasonable standard of care, or that the doctor has fallen below that standard of care. We will discuss the standard of care much detail after this. Now, the third element would be, after we have established that the doctor has breached that duty of care, the patient must then show that the doctor's conduct has caused the patient to suffer an injury or any kind of damage to the patient's personal body or life. And so we have the Bollums case when it comes to the standard of care. Bollums case is actually commonly known as the Bollums test. This case is now, you can see it is a very old case back in 1957, but it is this case that has become the universal yardstick for negligence case. So the question is that how do we know if a doctor is negligent? The test for this is to compare it at the standard of the ordinary skilled man exercising and professing to have that special skill. So if, for example, if I am a pediatrician treating children, the court would not go around and ask a gynecologist, for example, on how he would treat children, because then that would not be the same person professing the same skill. To give more context, the Bollums case is actually about a doctor who had not given the patient a specific muscle relaxant drug. So in the course of treating the patient suffered injuries during the procedure. Patient sued the doctor, and claimed that the doctor was negligent for not restraining the patient or giving them the muscle relaxant drug. And the court found that the doctor was in breach of this standard of care, because when they were to ask any other experts in this particular area, the other doctors would say that yes, we will have prescribed the muscle relaxant drug to the patient so that the patient will not move around too much and suffer any injuries in the course of treatment. This Bollums case as well, it says it provides the duty of provides the standard of care, and says that a doctor would not be negligent if he has acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art. It is a very mouthful test actually, but essentially what it means is that if you have one doctor to come to court today and tell the judge, yes, this doctor has acted accordingly, and this is how I would have done when I'm treating a patient in this particular area, the court will take that into account and will not find that the doctor is negligent. Putting it in a short story is that it is the medical profession and the doctors who will decide on negligence when it comes to a doctor's duty to diagnose and treat a patient. So if there is a doctor who comes on behalf of the patient and says that the doctor should have practiced in manner A, for example, and then on the other hand, we have the defendant doctor's expert to come and say, no, I would have done it in B as well, this is accepted. So based on Bollums test, the court will not find that the doctor is liable for negligence. So what happens when it comes to a doctor's duty to advise of risk associated with the proposed treatment? We have these Rogers against Whittaker test, more commonly known as the Whittaker test. So we have just now one is Bollums test, and now we have the Whittaker test. Now, in this case, the patient, Mrs. Whittaker, only had one good eye. It is her right eye. She had been blind in her left eye since she was 9 years old. Then at the age of 47, she was advised by the defendant doctor, that an operation on the left eye would improve her appearance and probably restore significant sight in the bad left eye. And so after being advised by the doctor, she agreed and undergo the procedure. But as it happens, she had a condition which resulted in her losing sight in that good eye, the right eye, which was her only source of sight since she was 9 years old. So the issue in this case is that whether or not the defendant doctor had actually failed to advise Mrs. Whittaker of this risk, even though it is only proven that the risk will occur 1 out of 14,000 cases. But in that particular case, the court said that the doctor had fallen below the standard of care by not advising Mrs. Whittaker of that risk. Because, for example, if the doctor had advised Mrs. Whittaker, it is something for Mrs. Whittaker to take into consideration. It is for her to decide whether or not she wants to continue with the surgery, knowing fully well that there is always that tiny bit of risk that will result in her losing sight in her right eye. So this goes to the concept of patient's autonomy, meaning to say a patient's freedom to make decisions concerning their medical care. But what happens is that the doctor did not advise Mrs. Whittaker on this. And being said that, Whittaker's test lay down the test when it comes to a doctor's duty to advise of the risk, is that the court will now determine whether or not the patient was properly advised of the risk by asking what the patient would want to know. So for example, just applying back to Mrs. Whittaker's test, if Mrs. Whittaker had known of the risk that she would lose sight completely in her right eye, there is that chance that she would not have agreed to undergo the procedure. But the story would have turned if the doctor said that, yes, I have advised the patient of this, the patient nevertheless agreed to go with the surgery. So that is a different story because the patient has made an informed decision on what would happen if she were to go with the surgery. So factors for the court to determine when it comes to the doctor's duty to provide advice with the proposed treatment is to consider several factors such as the severity of the risk, the patient's desire for information, whether or not the patient would think that particular information is material or important, whether or not the patient is capable of understanding the risk. Court will also look into the need for treatment and alternative procedures. These are the factors that will be decided by the court before determining whether or not the doctor is negligent. So this in contrast to the Bollums test earlier, where during the Bollums test, it is the medical profession who will determine whether or not the doctor has breached the duty of care. But if you were to make a comparison into the Whittaker test when it comes to the doctor's duty to advise of the risk, it will be the court to decide on whether or not the doctor has provided the sufficient advice. And this position, even though it comes from the UK English law, but the federal court in our Malaysian system, in the case of Fu Fiona, has affirmed the Whittaker test and say that this is test when it comes to duty to provide information and advice to the patients. And the federal court made it clear that the Bollums test, in terms of the doctor's duty to treat and diagnose, will not be applicable to the issue of advice and risk. So sometimes we do get questions on whether or not an error that was made during the surgery or treatment would amount to negligence. The answer is not necessarily. It would depend on the case. We have this case, Whitehouse against Jordan, as an example. In this case, the court said that it is only the error which has the degree of error which exceeds the accepted norm would amount to negligence. Long story short, not all errors would amount to negligence. And the judge in this case, Lord Denning, he said that if doctors were to be found negligent for whenever they make a mistake or whenever they could not find a cure, this would be a great disservice to the profession itself. In the case of Whitehouse, the defendant was actually in charge of delivering a high-risk pregnancy. Now, the defendant doctor was sued when the doctor tried to pull the baby out by using forceps. So in the course of pulling the baby out, the doctor caused brain damage to the baby, or rather the patient claimed that the doctor had caused brain damage to the baby. After evaluating all the evidence, the court found that the doctor was not negligent, simply because the doctor produced expert witnesses on his behalf who testified and said that the pulling of the baby using the forceps was not considered violent. In contrast, we will look at these three cases where the doctors had actually fallen below the standard of care. In the case of Chin Kiao, the doctor was negligent because he failed to ask whether or not the patient was allergic to penicillin injection. So without knowing and understanding the patient's medical history, and by giving penicillin injection, the doctor had caused the patient to have allergic reaction, and at the end of the day, patient died due to anaphylactic shock. The second case, when it comes to Chelaya manicum, is that the doctor had failed in diagnosing the patient's condition. The doctor failed to look into other symptoms. And he said that, yes, this patient had appendix, so we will be treating the patient for appendix. When in fact, the patient actually showed symptoms for pancreatitis. So when the patient was actually treated for appendix, which the patient did not have, she suffered injuries and died as a result of the surgery for the appendix. This shows a blatant disregard of, or rather the breach of the standard of care by the doctor's part. The third case, Khao Nan Singh, it talks about the doctor's lack of proper skill in the application of treatment, and also the doctor's lack of proper observation in monitoring the patient's response to the treatment after it was given. So what happened was the doctor had actually put the plaster of Paris around a cast around the patient's leg. The cast was actually put in a tight manner, too tight, the word was used as too tight, so that it affected the blood circulation in the patient's leg. So after a few days, when they realized it, the patient's toe was cold, the patient could no longer move his toe, and after they removed the plaster of Paris, removed the cast from the leg, they realized that the leg had actually become black. it turned gangrenous as a result of lack of blood circulation. And the patient had to amputate leg due to this lack of monitoring of the patient. So we have seen in several circumstances where the doctor had breached the duty of care. But are doctors actually expected to know all medical conditions? What if the patient has a rare condition which the doctor was not aware of, or in fact, the patient was not aware of as well? The case in Chin Tam Kong say that doctors are not expected to suspect a rare condition, and it would be reasonable to impose such a standard on them, especially when the patient comes to them and presented with several common symptoms. And it would be actually unreasonable to have the doctor to think of every rare condition under the sky just to diagnose the patient. So in such a case, it would be unlikely for the court to find that the doctor had fallen below a standard of care. Now, the next another important aspect in a medical negligence claim is the patient's medical records. A medical record is the documented information, everything about the patient's health, and whatever that is recorded throughout the course of the patient treatment in a medical center or a hospital. Now, the Malaysian Medical Council in their guideline, 2006 guideline, has actually listed out several documents which would constitute a patient's medical records. This would include the doctor's observations and clinical notes in the course of treating the patient. It would include the recording of discussions between the doctor and the patient, or with the family members, for example. It also includes referral notes for consultation and co-management, any kind of reports in terms of imaging reports when you do your MRI, CT scans, lab reports. If the doctor were to take photographs, for example, or video recordings of the surgeries, that would also fall into the medical records. Now, the importance of documentation to have a complete medical report is seen in the case of Zul Hasnima. We have always emphasized to the doctors to keep good documentation record, and the importance of it is reflected in this case. The patient alleged that the doctor failed to resuscitate the patient when the patient collapsed in the hospital. And upon going through the clinical notes and the medical records that was presented before the court, the doctor admitted that yes, she did not make any record that she had resuscitated the patient. But the doctor maintained that no, I did resuscitate the patient when she collapsed in the hospital. And the doctor managed to refer to a hospital record of the pharmacy items used. Now, based on these documents, it showed that there were 2 units of Hemacel. It's a medicine which were used in the maternity ward to resuscitate the patient. And the doctor has expert witnesses to come and testify that this drug, Hemacel, is used only for resuscitation and nothing else. Now, you would imagine that if in the court setting, in the litigation setting, the judge has no other information apart from the medical records here. So if there is no documentation of what was being done, what was being used in the medical records, it is only the patient's word against the doctor's word. So without this hospital record or the pharmacy item used, it is likely that the doctor will not be able to support his evidence that he had actually resuscitated the patient immediately after the patient's collapse. And if there was no evidence to support this, there is a good chance that the court may find that the doctor had fallen below the standard of care. It is proven, if it is shown that the proper method is for the doctor to immediately give resuscitation to the patient upon the collapse. Now, patients will actually able to obtain a copy of their medical records by submitting an application form to the hospital and pay a fee. Now, why would they be entitled to access their medical records? We have various reasons for this. Patients will require information so that the patient will be able to seek a second medical opinion. Once this information are documented in the medical records, such information would be presented to another doctor and they would know what kind of prescription, what kind of drug was given to the patient previously, what was the patient's condition prior to the treatment. All of this information would be available. It would also assist the patient to get further treatment at other healthcare facilities. And with all this information as well, the patients will be able to understand better of what their situation, their medical condition is. And most important also, if the patient is considering to commence a suit in court, the medical records would help them to determine whether or not they have a strong case to even begin the suit in court. So as I said just now, you can, or rather patients can actually submit an application form to the hospital, pay a fee, and based on the procedure, they would actually get a copy of their own medical records. But in reality-wise, this process is not easy or straightforward, because most of the time, hospitals and doctors will refuse such requests unless there is a court order. And the case of Nurul Husna, Muhammad Hafiz talks about this. The court says that the ownership of the medical records lies with the doctor or the hospital, because they were the one who create this document. But patients are entitled to get a copy of the medical records because it would be in their best interest. And at the same time, upon receiving the request from the patients, the doctor and the hospital has a duty to disclose such medical records to the patient. Now, this is in line with the Malaysian Medical Council's ethical guide as well. They encourage the disclosure of medical records to the patients unless such disclosure would be bad to the patient or any other individuals, or if the disclosure of the information in the medical records would cause serious harm to the patient's mental or physical health, or even endanger the life. Such situation is actually a bit extreme, and doctors will need to show strong reasons that they believe this will provide harm to the patient. This would usually concern patients with mental disorder. If they found out that they need to get a particular treatment, they would be mentally unstable, and that would affect their life. If that happens, then yes, it would be justified for the hospital to deny access to the medical records. And another reason for denial of the disclosure would be if no consent was given by the patient or from their next of kin if the patient is not is incapacitated or died already. But like I said, when it comes to the difficulties to get a copy of the medical records, hospitals would usually give the excuse on the grounds of confidentiality and say that, look, we cannot disclose all of this information to you because of PDPA, for example, or we will only allow you to have a copy of these medical records if you get a court order. This requirement to have the court order stems from Regulation 44 of the 2006 regulations. It says that no patient's medical record shall be taken out from the private healthcare facility except under a court order. So it is on this premise that most of the time hospitals would say, yes, you will need to come, you will need to provide and show that you already have a court order. Only then we will grant you a copy of the medical records. But the case of Nurul Husna say that, look, Regulation 44 only talks about the original copies of the medical record. At all times, hospital must ensure that the original medical records are kept within the premises of the within the hospital. And if for whatever reason the patient wants the original records, you will need to show a court order for it. But in no circumstances that the patient would need a court order just to have a copy of the medical records. So this is the distinction that the court in Nurul Husna say. Patients are entitled to get a copy of their medical records provided they submit the application form, they pay the fee, but there is no requirement to have a court order. At the end of the day, the hospital still requires a court order. The patient will be able to file a pre-action discovery under the rules of court. Once you file in that application and say that I have the consent from the patient or anyone else, or the patient specifically, the court will be able to intervene and grant a court order and direct the hospital to provide a copy of the medical records to the patient. But when we are actually advising doctors or hospitals, for example, we will always caution them about denying the access to the patients unnecessarily. Because at the end of the day, if the hospitals are being unreasonable in disclosing the medical records to the patient, the court may penalize the hospital in cost. So hospital will be subject themselves to a few thousand ringgit cost, for example, for causing hardships to the patient in getting such information pertaining to their own health condition. At the same time, if the doctor is unreasonable in refusing to provide any information in the medical records as well, he would be subjected to disciplinary sanctions because this is a breach under the MMC guidelines. So this is something to bear in mind when we are talking about the disclosure of medical records. I will let Chee take over from here concerning medical reports, expert opinions, and expert witnesses. Over to you, Chee.
Hi, thanks, Jasmine. Good afternoon, everyone. Let me just share my screen. All right, can you all see my screen? All right. Okay, so just now Jasmine was talking about medical records. Today I'm going to talk to you about medical reports, expert opinions, and expert witnesses. These are also important aspects in a medical negligence claim. Firstly, what is a medical report? Generally, a medical report is a piece of document. It is in the form of a report, which basically is prepared by a qualified medical practitioner. It's in regards to the patient based on the medical records that is given to the medical practitioner. So what do you usually see in a medical report? You usually see things like chronology and summary of the relevant evidence based on the medical records. So you probably start by seeing the date and time of admission, the preliminary diagnosis, final diagnosis, examination findings, management plans, treatment provided, and of course, if there are also operations and surgeries involved, you will see the relevant parts of the operation findings in this medical report. Now, this is to be distinguished from an expert's opinion. So an expert's opinion here, or some people usually call it expert's report. It is also in the form of a report prepared by also a qualified medical practitioner on a patient. But the difference here is that the whole document, the whole report, or the whole opinion is prepared for the purposes of addressing the questions that need to be addressed. So whether the doctor, the treating doctor who handled the patient was negligent when treating the patient. The contents-wise is roughly similar, but you have the scope of instructions. So the instructions of the question, the scope of what the expert is asked to address. And also you'll see chronology and summary of the relevant evidence similar to a general medical report. And lastly, and most importantly, is the medical expert's opinion in answering the question on whether they think that there was negligence or not. Of course, some experts, when they prepare the opinion, they will support their opinions with literature's findings to support their opinion or their theory. Now, who will prepare the expert's opinion in a medical negligence claim? So it is one who is an independent, qualified medical practitioner with the relevant expertise who must take a neutral position in preparing the report. So it cannot be just because that the patient has engaged, or rather the doctor has engaged the expert to prepare a report, that expert will have to cite that person. That is not the case. The expert must take a neutral position in preparing such a report. Of course, when the expert prepares the opinion or the report, they will have to be subject to, or they have to attend court to be examined. They have to provide our evidence, and their evidence and their qualifications will thereafter in the court proceedings, they will be cross-examined by the opposing solicitors. Now, some people will ask, why is an expert opinion required? Similar to the medical records that you have to file all these documents in court, a medical and expert's opinion will also have to be filed in court as evidence. So the patient, for example, will have to rely on this expert report to support his or her claim against the doctor. On the other hand, the doctors would also have to rely on this expert's opinion to defend the claim, to say that he's not negligent. So this is basically what an expert's opinion is. Apart from this, there are some other documents that are required here. I've listed here. An expert, when he prepares a report, he will also have to prepare an affidavit, form of a sworn statement to enclose the expert's opinion as well as his professional qualifications. So he has to attach his CV to be filed in court. Now, I'm moving on to expert witnesses here. So expert witness is basically the expert who prepares the report, who prepares the expert opinion. So who can qualify as an expert witness? I've listed down here that it has to be someone who is independent, who must not personally know the patient or doctor. The expert witness must be skilled in that particular field or particular area, must have the necessary professional qualifications. The expert must also possess the specialist and the technical expertise in the relevant subject matter. And lastly, and obviously, the expert must be able to attend court to be an expert witness. Now, what are the role of an expert witness in a medical negligence claim? An expert witness in a medical negligence claim is sort of like a consultant to the court. He has an overriding duty to the court in which he is to assist the court in technical matters or areas that are within his expertise. So he is expected to interpret or provide explanations on clinical, scientific, or even very technical issues which are usually outside the knowledge and expertise of the court, of the judge, of the lawyers. And the second point here that I want to highlight is that the duty, like I mentioned earlier, the duty overrides his obligation to the person from whom he has received instructions or by whom he is paid. So the overriding duty is to the court and not to the person who engages this expert to prepare the report or to be a witness. So being an expert witness, the expert must provide objective, independent, impartial, and unbiased evidence in this subject matter. When it comes to trial, when it comes to litigation and court proceedings, his expert opinion, his evidence in court, and whatever oral evidence that he is giving in court will be cross-examined, as I said earlier, will be cross-examined by the opponent party. So whatever evidence that he gives, he must ensure that the evidence given is accurate and not misleading, because he is the expert here. He should not be misleading the court or should not be misleading anyone when he gives his evidence. Of course, he will also have to take steps to check the accuracy of the information given whatever sources that he cited. Now, whether are actually expert witnesses and evidence necessary in a medical negligence claim? The short answer is yes, it is important. You can see this case here, Peramalu Anak Laki Virapan. In this case, the High Court held that it was important for the plaintiff to have adduced medical or expert evidence to support the allegations contained, and this could have assisted the court or thrown some light in arriving at its decisions. Unfortunately, there was no such evidence before the court. So in this case, the plaintiff or the patient's claim was eventually dismissed, and undoubtedly this is one of the reasons why, because the patient or the plaintiff did not have any expert evidence to support the plaintiff's claim. So it's very important to have an expert witness and also have an expert's opinion to support a patient's claim in a negligence claim. Similarly, to a doctor, if a doctor wants to defend a medical negligence claim against the doctor would similarly need an expert opinion or an expert witness to defend, to give their side of the story, to say that they are not negligent. Now, in the event that the court finds that the treating doctor was indeed negligent, the next thing for the court to consider is the assessment of compensation, or what we usually call damages for whatever injuries that were suffered due to the doctor's negligence. But how do the courts assess damages then? Now, to give you an idea of what is the court's view in terms of determining damages in a medical negligence claim, I refer to this case, Livingston and Yacht Co. It's an old case. The court actually held that any injury is to be where any injury is to be compensated by damages, you should, as nearly as possible, get at the sum of money which will put the party who has been injured or who has suffered in the same position as he would have been if he had not sustained the wrong. So basically, it is to compensate as much as if that the injury did not happen. Now, there are three types of damages that the courts will usually allow. Here, I've listed three types of damages: special damages, general damages, and aggravated damages. Special damages is basically losses that the patient has suffered arising from the injury that can be quantified. So I've listed some examples here. There are medical bills that the patient has incurred, whatever equipments, for example, maybe a wheelchair or crutches and all that. Whatever medication or treatment that the patient has to go through, maybe say, for example, physiotherapy sessions. These are all under special damages that a patient can recover because you have invoices, you have receipts to prove your the expenses that you have incurred. So hiring services as well. So if you have, because of the injury that happened, you have to end up engaging a maid to take care of the house. This may fall under special damages as well. And also loss of salary. So let's say if you are to be hospitalized for a few months and because of that you have lost a few months worth of salary, this falls under special damages as well. Now moving on to the second type, which is general damages. So general damages are losses, injury that cannot be quantified in monetary terms. For example, pain and suffering and loss of amenities. So how do you quantify this kind of pain and suffering? So let's say if you injure your hand, you expect a compensation, but how do you quantify how much pain you are suffering? So these are the things that you cannot quantify, and these are the things that fall under general damages. Also, loss of future earnings and loss future care expenses. These are things that fall under general damages. And lastly, the third one is aggravated damages. So basically, aggravated damages is losses that are to compensate for the aggravation of the injury suffered. So it is more of like the conduct of let's say the doctors or the hospital, which aggravates the situation. For example, causing delays in treatment or advising the patient to undergo some unnecessary treatment. So these will fall under aggravated damages. Now, I would like to focus more on the general damages in terms of the court's view or the court's determination in assessing pain and suffering damages, the general damages. How do courts assess general damages? The courts will usually look at, there's this document called a Compendium of Personal Injury Awards, or a compendium. Apart from that, the court will rely on case laws, previous cases in which the injury suffered by the patient is similar to the one in the case laws that are followed. So to give you an example, I have taken a screenshot of the compendium here. I think the words are a bit small, but so basically, if you can see this slide, it is regarding internal injuries. Internal injuries are usually very, very serious. So I've taken an example here, which is a brain injury. So this is basically a general description of internal injuries. And after that, you can see that they have each of the injuries suffered, they will have a table, and they will just quantify, they will just give a range of damages that can be allowed. So lowest being, say, for example, subdural hematoma with burr hole craniotomy. So lowest would be 18,000, the highest would be 30,000. Or if you are talking about memory impairment, the lowest would be 24,000, the highest would be 55,000. Now, of course, this compendium is not to be strictly followed. The court would use this as basically a guideline to assist the court in ultimately deciding how much the damages should be. The court, as I said, will also look at case law. So let's say we're talking about brain injury. This case, Ahmad Tawqif Hamza bin Ahmad Huzairi, this case involves severe and irreversible brain damage. This plaintiff is actually only 10 years old. but he has suffered brain injury and eventually he became a cerebral palsy patient due to the doctor's negligence in failing to discover all his condition earlier. So in this case, the court awarded a general damages in the sum of 350,000, but this is based on the compendium, the table that I showed you just now, and also previous case laws which supports this amount of damages. Another example that I would like to show is spinal or nerve injuries. So again, there's a general description in the compendium, and then there will be a table which you can see the range of the damages that you are expected or you are likely to obtain. So see, for example, fractures of vertebra will be 22,000 to 42,000, or if you're talking about whiplash injury, it will be 9,000 to 14,500. So these are just a range of damages that you are expected to obtain, to get. So this case that I'm showing here is also a case of spinal injury. It's called Muhammad Sabri bin Muhammad Vin. It's quite a recent case, 2017 case. This case involves injury to the vocal cord, scarring from operation, as well as injury to the cervical spine due to the surgery performed by the defendant doctors. The plaintiff here in this case claimed for 250,000 for general damages for pain and suffering. But in the end, the court decided to award general damages in the sum of 130,000 on the basis that is more reasonable and based on compendium and also based on previous case laws. The court was of the view that 130,000 is a more reasonable amount. Now, so when the court is assesses the general damages for pain and suffering or for future care expenses and all, these are the factors that the court will take into consideration before they reach a decision on how much to award. Seriousness of the injury, how the injury affects the quality of life of the plaintiff, or whether the plaintiff is required to undergo any future treatments or follow-up treatments. And in some cases, for example, the cerebral palsy case, the court will also take into account, say, for example, the life expectancy of the plaintiff, as well as the age of the plaintiff. Of course, this is not just the only factors there are. I'm just listing down a few factors here. Now, involvement of the lawyers. So I added this slide to tell the audience here is that for a medical negligence claim, you would generally want, whether or not you are claiming or you are defending, you generally want your lawyers to be notified or to be informed as early as possible, so that the lawyers can we can advise on whether or not you have a good case or in claiming or in defending. And before it reaches to court proceedings, we might also assist in negotiations with the opponent, the opposing party. And of course, if the negotiations fail, then the next step will be to file a claim or to file a defense after the claim is served. In the case of doctors being sued, the hospitals or doctors should also notify insurance as quickly as possible regarding the possibility of dispute, so that there might be procedure of insurers appointing lawyers to help defend the case. Now, I have reached the end of my slide. I hope you all find this helpful and you all gain something from it. I'll pass back the floor to Amira.
Hi, Chee. Thank you so much for the presentation just now. We will proceed with the Q&A session, and the speakers will be answering the questions that have been posted in the Q&A chat box. So for the first question, we have from Boon Seong Lim. He asked, what are the damages typically awarded in Malaysian court due to medical negligence? Chee, can you answer this one?
Hi. Sorry, the damages typically awarded. Yeah, so I think I've covered this in my slides earlier. Damages that are awarded are usually special damages, general damages, and sometimes also aggravated damages. But of course, to prove all these damages, you need to have documentary evidence for special damages. So you need to have receipts, you need to have invoices that you have incurred these kind of losses. For general damages, it is more towards the compendium and the case laws that the courts will usually follow. And lastly is aggravated damages. It is also not quantifiable, but this is also based on case laws. So these are the damages, the typical damages that the courts usually allow in a medical negligence claim.
Thank you, Chee. The next question is also from Moon Seong Lim. He asked whether we can use arbitration in medical negligence cases, and in what circumstances do you settle out of court or proceed to defend? Jasmine, can you answer for this one?
Thank you, Mira, and thank you for the question. Well, first question, whether we can use arbitration to litigate a medical negligence claim. First of all, both parties must actually agree to use arbitration instead of having the matter heard in a civil court. The process for an arbitration may be flexible, but one thing to bear in mind is that it would be expensive because parties will need to appoint an arbitrator and pay for the arbitrator's fee for each day of the hearing. And if I'm not mistaken, parties will also need to pay for the rental of the arbitration room. So all of these costs, if you add up together, it may go up to quite a large sum of amount, because arbitrators' fees can go up to a few thousand per day, depending on the expertise of the arbitrator. As to the second question on whether parties would settle, or rather whether the defendant doctor would settle out of court or proceed to defend, well, that would depend on the case really, and specifically what was being advised by the defendant's expert witness. Because if the defendant doctor had, for example, operated on the wrong side of the patient's body or left a surgical equipment in the patient's body, this is a clear-cut negligence. And in such situation, doctors would generally want to settle out of court. But if the case is sort of borderlines on a 50-50, and especially if you have the defendant's expert witness coming to you and tell that, yes, the doctor has actually acted accordingly with the accepted practice, then it would be likely for the doctor to proceed to defend, because it would be for the court to decide whether or not the doctor's conduct, for example, can withstand to logical analysis, and whether or not the doctor has fallen below the standard of care. So it really depends on the facts of the case.
Okay, thank you, Jasmine. Anonymous asked, what is the limitation for requesting for medical records? Let's say if the incident had happened 3 years ago, for example. So, Jasmine?
Well, if a patient was treated in a private hospital, you will still be able to apply to get a copy of the medical records, even though it happened 3 years ago. Because private hospitals, they usually will keep a copy of these medical records for about 6 to 7 years. And this is because that is the limitation period for the patient to commence a negligence suit against them. But if you're talking about a government hospital, for example, they may keep the records for a shorter duration of time, because under the Act, the patient has only about 3 years to commence a suit against a government hospital. But if we're talking about the patient who is a child, for example, the limitation period may be longer. Then the hospital may keep the medical records for as long as the limitation period would stand. But either way, we would definitely advise to get a copy of the medical records as soon as possible if you suspect that there is an issue with the medical treatment.
Okay. We have a question from Miss Sandy Wee. Hi, Chee. Do experts also involved in assessing or quantifying general damages?
Hi. Sorry, there was some problem with my internet just now. So sorry.
Mira, what is the question? Sorry.
Okay, I'll repeat the question. Ms. Sandy asks, are experts also involved in assessing or quantifying general damages?
Sorry, are you directing this question to Jasmine or
to you, Chen?
Oh, so sorry. Sorry. The whether or not the experts are involved in assessing the damages, right?
Yes.
I see. No, the experts may suggest that these are the patient has suffered this injury, and the patient is expected to undergo future treatments and all. But then, in terms of ultimately whether or not how much the patient is able to get from the damages, that ultimately is the discretion of the court, not from not from the expert. If you're talking about assisting, or rather just a suggestion of claim, maybe the expert may suggest that these are the things that the patient has suffered. But ultimately, as I said, the discretion is to the court's discretion to allow however much that the patient is able to get.
Okay, thank you, Chien. We have a question from Anonymous. The Anonymous asks, can we sue a doctor for misdiagnosis? So for example, my mom was diagnosed orally with piles when she discovered blood in her urine. But after going for further consultation, she was found to have uterine cancer. So can we sue the first doctor that simply diagnosed orally without further checking? Jasmine, can you answer this question?
Well, whether a patient can sue the doctor for misdiagnosis, a patient has the right to commence a suit, and misdiagnosis is one of the common cause of action as well. But whether or not the patient can actually succeed, that is a different story, because as we have discussed earlier, patient would need to show that there is a breach of duty on the part of the doctor, and the doctor's conduct had caused the patient to suffer injuries. So in this situation, I understand that the patient had uterine cancer, right, Mira?
Yes.
And yeah, so we will need to show we will need to get an advice from expert witness, for example, to say whether or not the doctor had actually done all necessary investigation or examination to before diagnosing the patient with her condition. And if the expert witness say that the doctor did not do a specific or a particular investigation before coming to a conclusion that the patient does not have uterine cancer initially, then yes, that would be a cause for a claim in medical negligence.
Okay, thanks, Jasmine. We have the next question from Mr. Simon Tay. This is relatable to our current times with the pandemic. He asked, will a volunteer for the AstraZeneca vaccine be eligible for medical negligence if its side effect resulted in hospitalization costing to 12,000? Jasmine, yes?
This is a good question, actually, one which is commonly discussed nowadays. Okay, you see, we are talking about the AstraZeneca vaccine in this particular case. As far as I'm aware of, the government has not actually used the AstraZeneca vaccine in the government program. And this AstraZeneca vaccine was previously given under the opt-in program. So as was stated in the question as well, this is a volunteer who has volunteered to take this vaccine. If I'm not mistaken, before anybody takes the AstraZeneca vaccine as well, there was a consent form given to the person. As a volunteer, and by signing the consent form, the patient, or rather this person, would have agreed that they may be risk, and this person would have voluntarily accepted the risk, unless that this particular individual would be able to show that I was forced to accept or to take AstraZeneca vaccine and goes against what I was advised on, or whatever strong grounds. Then unless you can show that, I think it will be difficult to commence a suit based on this ground alone.
Thank you, Jasmine. Next question, Ms. Judy. Since the medical reports are owned by the hospital/doctors, would it not be subject to non-self-incrimination principle, such that the reports can be denied to be provided? What can the plaintiff do then in such a case? The hospital or doctor may provide reports selectively only, and the patient may not be aware that some parts of the report are not provided. Jasmine, I believe this is your question.
I think the question is actually asking about medical records which are in the hospital's possession. Yes, previously, on behalf of the patient, that was the exact argument that was advanced before the court. The patient lawyers would argue to say that, look, all of this information concern the patient. So on what ground is the hospital refusing to disclose such documents upon being asked, upon being requested? And as we've mentioned before, previously that was the case. Hospitals would require a court order for it. But as we have seen nowadays, most of the time, the hospitals would agree to disclosing a copy of the medical records upon being asked or requested by the patient. And if they still refuse to do so, the patient can file an action in court to seek court's intervention and get a copy of these medical records. And if the hospital if the hospital refused to comply with the court order, that would be contempt of court, and the hospital would be liable for contempt. There would be a fine as well. So if any lawyers, if we are representing the doctors or the hospitals, we would definitely advise for the disclosure of the medical records unless there are any strong grounds for not disclosing them.
Okay, I think we have time to just answer just a few more questions. One question is, the normal limitation period to commence a tortious action is 6 years. What if the patient could only discover the damage done to his body after 6 years? Will the limitation be postponed until the date of discovery?
I think it based on the Limitation Act, it's there is a definition of the starting date that Section 6A sub 4 of the Limitation Act defines starting date as the earliest date on which the plaintiff or the person in whom the cause of action was vested before him had both the knowledge required and also a right to bring in action. So correct me if I'm wrong, Jasmine, I think the commencement date would depend on whether the person, when the person has first-hand knowledge of such a injury.
That will actually, if you look into Section 6 of our Limitation Act, it says that the date starts on the cause of action itself. I believe some of the questions also ask about when the patient discover the injury. Well, first of all, we will need to see what is the age of the patient, for example, because different limitation applies to child or a person who is mentally disordered. But at the end of the day, it falls back to the cause of action when it actually happened. As far as I'm aware of, the act concerning the knowledge, for example, subsequent knowledge, it doesn't apply to negligence. This is pursuant to the new provision in our Limitation Act, Section 6 sub A.
Thank you. The next question is, I believe, is directed to Chee. Is the compendium prescribed by local authorities, and is compendium only applicable in Malaysia? Are there any other guidelines applicable for assessment for damages other than the compendium?
Sorry, can you repeat the question again? Whether or not there are any other
guidelines applicable for the assessment of damages other than the compendium?
To my knowledge, the compendium and the case laws are the guidelines that the courts will usually follow. If you're asking if there are any other guidelines, to my knowledge, I don't think so. But of course, if a patient is is intending to depart from the compendium, there's one case, I cannot remember on the top of my head, there's one case which is that if the patient is intending to depart from whatever is prescribed in the compendium, the court will follow that. The court will allow, provided that the patient is able to prove whatever guidelines or whatever sources that they can rely on to depart from the compendium.
The last question before we close the Q&A session. In your legal experience, how difficult or easy is it to get a medical practitioner to agree to be an expert witness? Are medical practitioners generally reluctant to act as an expert witness?
Yes, I would say both patient and the defendant doctors generally have difficulties in securing an expert witness to go to court and testify on their behalf. There is definitely the practice where doctors do not want to testify against their own colleagues, or maybe because the process of going to court and the long duration of the litigation case itself is too troublesome. And for various reasons, generally, it has been quite a journey to get expert witness for both the plaintiff and the defendant.
And bear in mind that the expert will also have to attend court. So let's say if it's on a weekday, then the expert might not be able to open their clinics and all that to just to attend court to give evidence.
Yeah, so there is the cost issue as well, because from the doctor's point of view, they will not be able to collect fees on the day that their clinic is closed.
Okay, thank you very much. I think we will conclude our Q&A session until now. Thank you, Jasmine and Chee for your insights. Before I conclude, I have a few announcements to make. First, please join us again for our upcoming talk. The next upcoming talk is regarding business defamation and social media, which will be held on 18th of August 2021. Our speakers will be our own partner, Mr. Gan Chong Chir, and our associate, Mr. Eric To. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. And please follow our social media accounts. The link will be all given in the chat box. And fourthly, if you would like to speak to our lawyers, we offer a complimentary 30-minute video consultation with our lawyers. Please fill in the form on our website and the link will be posted in the chat box. So to our guests, thank you for joining us. We hope you find today's session informative and useful. Thank you very much.
Thank you very much for attending.
Thank you.